Hi, my name is Kevin Webb. I'm the training manager in the Title IX office at Howard University. Welcome to Howard. Um, uh, as you see on the screen, the Title IX director and Title IX coordinator for the university is Leslie T. Anixtein, Esquire. And we also have two investigators in our office, Miss Angie Logan Pope and Miss Caitlin Myron. So we're a staff of four. What we want to talk about today is what Title IX is and why it's important, the university's Title IX policy, and your rights, resources, and responsibilities under the university's Title IX policy. So first, what is Title IX? You may have heard of Title IX, you may have some sense of what it is, but Title IX is a federal law that prohibits discrimination based on sex or gender in any education program that accepts or receives federal funding. So Howard receives federal funding through federal financial aid for students, through research grants, and in other forms. And what you see here on the screen in quotes is basically the full text of the Title IX law, which basically says no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So that's the federal law that's known as Title IX of the Education Amendments of 1972. Now, when Title IX was first passed, you mainly heard about it in the context of college athletics, basically saying that if you had a certain number of opportunities or programs for men to play sports at the collegiate level, that you also had to have a proportionate number of opportunities for women to play sports at the collegiate level. More recently, in the past decade or so, you mainly hear about Title IX discussed in the context of another issue on college campuses, which would be the issue of sexual assault and sexual harassment on college campuses. Sexual assault, sexual harassment are just two forms of sex or gender-based discrimination or harassment that are prohibited under the Title IX law and under our Title IX policy. There is a range of behaviors that are prohibited under the policy and that our policy addresses and protects you from as students. And so we're going to talk about all of those. So who does Title IX apply to? So often people think it only applies to undergraduate students. Maybe they think it expands it to, they may expand it to include graduate students. It applies to everyone at the university. It applies to all students, undergraduate, graduate, transfer, foreign or domestic exchange students. Whether or not you are a US citizen, if you are a member of the Howard University community, this Title IX policy applies to you and protects you and gives you resources and recourse if you ever have a concern or a complaint or an issue related to sex or gender-based discrimination, harassment, or violence at the university or involving you or other people from the university. It also applies to faculty and staff. It applies to all individuals on university premises or any other property where the university conducts business. So that could be parents, visitors to campus, contractors, if they are on our campus or doing business with the university or interacting with the university in some way, participating in a university program that the university sponsors, whether it's on or off campus, such as a study abroad program, off-campus housing, an away game when it comes to college athletics. In all of those situations, our Title IX policy still applies, and again, is designed to protect all of us from sex or gender-based discrimination and provide resources if we experience anything related to those issues. In terms of what's covered by Title IX, all aspects of our school's education programs and activities are covered, from admissions to academics to athletics to residence life, employment, extracurricular activities, and again, all programs that the university is participating in or sponsoring on or off campus. So a Title IX grievance process, so if someone makes a report to our office of some type of Title IX policy violation, what the policy requires us to do is when we become aware of any sort of sex or gender-based discrimination, harassment, or violence, we have to take steps to stop the discrimination or harassment, to remedy the harm that's been caused to the person who's alleged to have been harmed, and to prevent future reoccurrence of that Title IX policy violation, whether it's harassment, discrimination, or violence related to sex or gender. So one of the things that our Title IX policy does is it defines all the forms of prohibited conduct. So these are the things that the policy says are forbidden or prohibited under the policy, and that if you experience or learn of any of these things happening at the university, that you can make a report to our office for us to address, or there are other resources you can access on campus. So it really just depends on, if you're the person who's experienced it, how you want to respond and address what you've experienced. And we'll talk about the various options in a moment. The policy has full, longer, more detailed definitions of these terms. And the full policy is about 38 pages. We have created a one-page summary of that policy that's available to you via our website. And it basically gives you a summary of the key provisions of the policy, and at a glance you can understand what your basic rights, resources, and responsibilities are. But one of the things the policy does is provide definitions, and we'll go through some of these definitions briefly. We'll go through all of them, but briefly, and I encourage you to read the definitions in the full policy at your earliest convenience. So the forms of prohibited conduct under the policy include sexual assault, sexual harassment, gender-based discrimination or harassment, sexual exploitation, dating and domestic violence, stalking, retaliation, complicity, and there's a prohibition on certain kinds of consensual sexual or romantic relationships at the university. And we'll talk about all of those. So first, what is sexual assault? Well, in short, sexual assault is basically any form of non-consensual sexual contact. So any unwanted or unwelcome physical contact of a sexual nature would constitute sexual assault. I'll read the first part of what's on screen here. It's any act of vaginal or anal intercourse or penetration, however slight, by a person's penis, finger, other body part or object, oral genital contact, or other intimate parts without consent. Keywords being without consent. So again, if any of these things is done to someone without their consent, that would constitute a sexual assault and could be reported to our office for us to look into. So what's sexual harassment? You've probably heard of this term. Sexual harassment is basically any unwelcome sexual advances, requests for sexual favors, and or other verbal or physical conduct of a sexual nature. I'd also include written or graphic content, so things that are posted in an area, displayed on someone's cell phone and shown to someone in the workplace or in the academic environment, things that are shown on a computer screensaver, anything that could be inappropriate to the learning or working environment and is of a sexual nature. Any of those things could constitute sexual harassment when they meet one of the following three conditions. So the first condition would be that submission to or rejection of the sexual conduct is made a condition or a term of your academic standing or of your employment. If, let's say, you are a teaching assistant or have some other job on campus, and that could be whether it's explicitly or implicitly made a condition of your academic standing or employment. And the second condition would be if your submission to or rejection of the conduct is used as a basis for evaluating you, so evaluating your academic performance or your work performance. And both of those two conditions would constitute what we call quid pro quo harassment. You've probably heard of that term. Quid pro quo is a Latin term that basically means this for that, right? You do something for me, you'll get something in return. Or phrased differently, if you don't do something for me that I want from you, then you will get something in return that you don't want or don't like. So just as an example, if you watch TV shows or movies and they want to show you an example of sexual harassment, let's say in an academic context at a university, they might show you a professor saying to a student, if you go out with me, you will get certain kinds of things in return. What kinds of things might those be? Could be a better grade, less work to meet the requirements, or it could be phrased differently. If you don't go out with me, then you will get some other things in return that you don't want, which could include a failing grade, perhaps. So that would be quid pro quo harassment. And quid pro quo harassment happens, but the more common form of harassment that we see is hostile environment harassment. And that's where there's just some behavior happening in the academic environment or in the workplace that creates a hostile environment such that it makes it difficult for you to continue your education, for you to study, for you to participate in class, for you to work, if we're talking about an employment context. That could be behavior that's directed at you specifically, or that is just behavior that you're exposed to, such as the examples I gave earlier about inappropriate conversations or inappropriate things posted in the workplace that you are forced to see, which create a hostile environment in that they are offensive and impede your ability to study or do your job. So one example of that might be requests for dates. Asking someone else on a date, generally asking once and the person says no and you leave it alone, that's generally not considered sexual harassment. But if, for example, someone asks you out on a date, you say no, the next day you come into class, they ask you out again, you say no, and then this scenario repeats itself over and over again. Now we're getting into territory where there could be a complaint or report of sexual harassment because it's potentially creating a hostile environment where it's making it difficult for you to come in and just study and participate in class because you're constantly being bombarded with requests for dates when you've already said no, and let the person know that it's unwelcome and unwanted. And as it says here, a hostile environment exists when the conduct is sufficiently severe, persistent, or pervasive that it unreasonably interferes with, limits, or deprives you from participating in or benefiting from your educational program. Or again, it could be in an employment context. Gender-based discrimination or harassment is any intentional or unintentional act that results in someone being excluded or denied a benefit of their education or their employment based on their sex or gender identity, based on their gender expression or their nonconformance with gender stereotypes, based on their sexual orientation, or based on pregnancy. So pregnancy discrimination is also a form of sex or gender-based discrimination. So when we're talking about sex, maybe we're talking about someone's sex assigned at birth or their biological sex, so being discriminated against because we're male or female, or being discriminated against because we identify as non-binary, meaning being neither male nor female, or being gender fluid. So when we talk about our gender identity, that's how someone identifies. And the way this comes into play at the university often is in two scenarios. One is that under DC law and under the university's Title IX policy, we're all allowed to use the restroom that corresponds to our gender identity and not necessarily to our sex assigned at birth or our biological sex or our physical anatomy. So no one is allowed to chase us out or force us to leave a restroom because in their perception, they're thinking that we don't belong there because of how we look, because we don't look like we are, quote, the right gender to be in that restroom. As long as someone is engaging in normal restroom behavior, which is basically using the restroom, then we are to do the same, engage in normal restroom behavior. And again, we do not have the right to force someone to leave because of our perception. And no one is allowed to force us to leave because of their perception that we don't belong in the restroom. Another way this comes into play in the classroom in another context would be in terms of people's chosen names and pronouns, right? The names and pronouns that people use. So I, for example, am male. My sex assigned at birth is male. My gender identity is male. I identify as male, and I go by he, him, his pronouns. But if, for example, I said that I identified as female and wish to be referred to by she, her, hers pronouns, then everyone would be expected to respect that. Now, no one's going to be disciplined for making a mistake and mistakenly referring to someone by the incorrect pronouns. But if someone corrects you, if we make a mistake, which we very well may, and someone corrects us, we basically just simply thank them for correcting us, apologize for making a mistake, and we try to correct it going forward. Because intentionally calling someone by a different name or different pronouns from what they've expressed that they want to be referred to as would be considered misgendering someone, right? And that would be a form of discrimination, of sex or gender-based discrimination. So we want to be respectful of how people want to be referred to in the classroom, in the residence halls, and everywhere on campus, and in all of our interactions with other members of the Howard University community. And again, sex or gender-based discrimination also includes discriminating against someone based on sexual orientation, pregnancy. And when we talk about gender expression and nonconformance with gender stereotypes, that could include someone's manner of dress, someone's mannerisms, those kinds of things that one might associate with a particular gender, with either being male or female, or our perception that someone doesn't conform with certain gender stereotypes. So again, we're all protected from discrimination based on any of these aspects of our sex or gender identity or sexual identity. So what is sexual exploitation? Sexual exploitation is any act where one person violates the sexual privacy of another person or takes any kind of unjust or abusive sexual advantage of someone else without their consent. So there are many examples of this. One of the main examples or most common types of sexual exploitation that we see at the university would be what they call revenge porn. Some of you may have heard of this. Revenge porn, basically, for example, is if two people are in a relationship, they exchange nude pictures, or maybe they make a video of themselves engaging in consensual sexual activity with each other. They break up, one person is angry at the other person, and as an act of revenge takes that video or those pictures and posts them on social media, or otherwise distributes them electronically or posts them for other people to see. That would be a form of sexual exploitation. Also, if two people agree to engage in consensual sexual activity with each other, but one person decides to make a video or recording or take pictures of it without the other person's knowledge or consent, that would also be a form of sexual exploitation. And finally, spying on someone would also be a form of sexual exploitation, whether it's hacking into someone's web camera to watch them get undressed or engage in a sexual activity, live streaming someone's sexual activity without their knowledge, or even hiding in person and watching someone engage in sexual activity without their knowledge. Those would all be forms of sexual exploitation. And again, could be reported to our office as something for us to look into if it involves people from the university. So what is dating and domestic violence? So I think that most people would probably think of physical behaviors, so physical violence when you think of dating and domestic violence, and it does include that, but it's not limited to that. So dating and domestic violence is a pattern of controlling behaviors used by one partner in a relationship to control the other partner. And there are many forms of dating and domestic violence. It can, of course, include physical abuse. It can include sexual abuse. It can include psychological and emotional abuse, so constantly berating or belittling or demeaning someone, threatening someone with physical violence, even if the person does not follow through on committing physical violence. That in and of itself would be a form of dating and domestic violence. And economic abuse, withholding someone's money, preventing someone from going to work, or preventing someone from going to class would also be economic abuse, because classes cost money, and also long-term, people are ostensibly going to school to be able to have a future career. And so that would be impeding progress toward that. So those would all be forms of economic abuse, and all of these would be forms of dating or domestic violence. Similarly, stalking, I think most people would think of physical behavior. So following someone from place to place, following someone home, following someone to class, following someone to work can be particularly easy to do on a college campus because it's easier to monitor people's daily routines. But it's not limited to physical behavior. It can also include what we call cyber stalking, using electronic means to track or pursue someone who's already indicated that they do not want to be contacted. So if someone's constantly or continuously sending you texts or emails or phone calls when you've already said you don't want them contacting you, or reaching out to you on social media through direct messages, or tracking your whereabouts via social media, or after you block them, getting their friends to track your whereabouts on social media and report back to them. Those would all be forms of stalking. Retaliation is also explicitly prohibited by our policy, and retaliation includes any acts or words taken against an individual or group of individuals involved in a protected activity. So making a report to our office if you believe you've experienced sexual harassment or stalking or any type of Title IX policy violation is a protected activity in that you have a right to do it, and no one is allowed to retaliate against you for doing so. And if, for example, you reported to our office that you believed you were being sexually harassed, and we were to investigate it, and we determined at the end of the investigation that, we believe you brought the complaint in good faith, but based on the evidence, we were unable to find the person responsible for sexual harassment, that person is not allowed to then retaliate against you for having made the report. because that could lead to another separate complaint of retaliation, and a person could be found responsible for the retaliation, even though they were not found responsible for the initial harassment. Complicity is any act that knowingly aids, facilitates, promotes, or encourages someone else to commit a Title IX policy violation. So, you know, if I were to say to my friend, why don't you go over there and grab that person, or say this inappropriate thing to that person, you know, something of a sexual nature, or encouraging others to get together and retaliate against someone for having made a complaint about our friend. Those would all be forms of complicity. And if I were to do that, for example, I could be found responsible for complicity, even if the person who I was trying to encourage to violate the policy does not follow through and do what I was trying to encourage them to do. So that's complicity. So consent, we've heard consent come up as we've gone through these different definitions, because we're always talking about things that are done to someone without their consent as being violations of the policy. Here we're talking about consent specifically in the context of sexual interactions or sexual activity. Consent is a voluntary, informed, and freely given agreement, either through words or actions or both, to participate in mutually agreed upon sexual acts. Consent to one act does not constitute consent to another act. Consent on a prior occasion does not constitute consent on subsequent occasions. Consent can be modified or withdrawn at any time. So if two people are engaged in sexual activity and one person says they want it to stop, it's supposed to stop. Consent cannot be inferred from silence or lack of resistance, and an individual who is incapacitated cannot give consent. When we talk about incapacitation, one of the most common ways people become incapacitated would be through use of drugs or alcohol. Drugs or alcohol do not cause sexual assault, but they're the most common tools, among the most common tools used to incapacitate people. And when we are talking about incapacitation, it's not just being drunk or being high, because one can be drunk and give consent to sexual activity. However, when we talk about incapacitation in the context of drug or alcohol use, we're talking about being so intoxicated that maybe one is passing out or doesn't know how they got there, doesn't know how they became engaged in sexual activity. Those will be some signs, not the only ones, but some signs that someone is incapacitated and cannot give consent to sexual activity. But drugs or alcohol are not the only ways that people can become incapacitated. Someone who is asleep cannot give consent to sexual activity, or who's unconscious for some other reason cannot give consent to sexual activity. So that's consent. What kinds of consensual relationships are prohibited by the Title IX policy? In short, employees cannot date students at Howard University, and that includes student employees. So if you're a teaching assistant, a student who is a teaching assistant can date other students, but you cannot date students who you are currently teaching. Similarly, if you're a resident assistant or a GA in a residence hall, you can date other students, but you cannot date students who live in the dorm where you work. And this is all to prevent abuse of power, to prevent conflicts of interest, to prevent things like favoritism or the perception of any of those things, right? That could create a hostile environment or even lead to complaints of quid pro quo harassment. So again, employees cannot date students at Howard University. So what can you do? If you believe you've experienced any type of Title IX policy violation, any of the behaviors that we've talked about, you can report it to the Title IX office. You can do it by calling or emailing us. Currently, we are working remotely. Normally, when we are on campus, we have walk-in hours, but you can call or email us. We can also schedule video appointments to do video interviews. You can also report the incident to law enforcement. If we're talking about something that could also be a crime, such as a sexual assault. You can report the incident to a responsible employee, and we'll talk about what that means. These are employees who have an obligation to report anything they become aware of related to sexual misconduct to our office. Or you could seek help from a confidential employee or resource on campus. You can do one of these things, you can do two of these things, you can do all of these things, you can do none of these things. It's really up to you how you want to respond to what you have experienced. But we want to make sure that you understand that you have a variety of options that you can access. It's also important that you know that if you are a student employee on campus, or if you're a TA, a GA in a residence hall, or you have another position of employment on campus where you have responsibility for students, that you are what it would be considered a responsible employee. Basically, all employees of Howard University, with the exception of those who are considered confidential, have an obligation to report anything they become aware of related to a potential Title IX policy violation to the Title IX office, so that we can do outreach and make sure the person is aware of their rights and the resources and of their right to make a complaint to our office or to access other resources on campus. So if a student were to disclose to you, if you're a TA or a GA in a residence hall, for example, that they experienced some type of Title IX policy violation, then you would be obligated to report that to our office. But you should also be able to refer them to confidential resources for support on campus. So confidential resources, any employee on campus who, because of their professional license and what they do at the university, can keep disclosures of sexual misconduct confidential. That would include clergy, so people in the office of the chaplains, licensed medical, clinical, or mental health professionals, so medical professionals at Howard University Hospital, the Student Health Center, counseling service. They would all be confidential, as well as any administrative employees who support them. However, they're only confidential in the context of their confidential role. So if, for example, we have a counselor who works in the counseling center but also teaches a course at the university. If a student comes to them for counseling and discloses that they've experienced, say, sexual harassment or sexual assault, that's confidential, and that counselor should not report that to our office unless that student is seeking their assistance in reporting something to our office. If they're teaching a course and a student discloses in a paper that they've been sexually assaulted, or if a student comes to them after class and discloses that, or if that person is just walking to the parking lot after work to their car and they witness an incident of dating or domestic violence, those would all be reportable. Those would all be things that that counselor would have to report, because those were disclosed not in the context of a confidential counseling relationship, but in the context of their role as an instructor or as just an employee walking across campus who received this information, again, not in a confidential context. So that's the difference between responsible employees and confidential employees. So again, if you're a teaching assistant or graduate assistant who has responsibility, some form of responsibility or supervisory role or teaching role over students, in that context, you would be a responsible employee and would need to report disclosures of sexual misconduct to the Title IX office. There's an amnesty policy. As you know, as you may have heard, Howard University has a policy against drug or alcohol use on our campus, but to encourage reporting and remove barriers to reporting, if one were to report a Title IX violation to our office, but also disclose that one was drinking or using drugs at the time that they experienced a Title IX policy violation or witnessed it, they would not be disciplined for the they would not be disciplined for the drug or alcohol violation because they are making a Title IX report. The exception would be if the drug or alcohol use put someone else or other people at risk or in danger. So an example would be if someone were drinking and driving when they witnessed a potential Title IX policy violation. In that case, they might be disciplined for the drug or alcohol use, even though they're also making a Title IX report. So often people think that when something is reported to the Title IX office that there's automatically a formal investigation. That's not the case. There's a range of responses that we can offer. In some cases, we determine that what's being reported would not be a Title IX policy violation, but might be a violation of another university policy, in which case we would refer it to the appropriate office to look into and address. We also offer alternative resolution, generally not in the case of sexual assault, but in other types of violation. An alternative resolution might look like a mediated conversation, might be an apology if that's what a complainant wants. It might be a letter of warning. It could be a range of things that could result from alternative resolution. We also offer accommodations and interim measures, protective or remedial measures. So that could be academic accommodations. If a student says they need to get an extension on an assignment or be able to take an exam on another date because they, for example, needed to seek medical attention following, let's say, sexual assault or an incident of dating or domestic violence, or if someone says they experienced stalking or harassment in their dorm, we could get them moved to other residential accommodations, we would work with the appropriate departments to implement those accommodations. We can issue no contact orders, which are always mutual. So if you request a no contact order against someone, you also cannot contact that person as well. We can refer people to some of the confidential resources or to other offices on campus, such as the Interpersonal Violence Prevention Program, Counseling Services, or Department of Public Safety. And there are other kinds of interim remedial and protective measures that we can offer. So some of the confidential resources that are available to you, if you want to speak with someone confidentially about a matter related to sex or gender-based discrimination, harassment, or violence, include the Interpersonal Violence Prevention Program, which are victim advocates who work with people who've experienced sexual violence or dating or domestic violence. The University Counseling Center, the Office of the Chaplains. For medical assistance, there's a Student Health Center, Howard University Hospital, and it's important to note that MedStar Washington Hospital is where DC's sexual assault nurse examiners are based. They are the ones who can administer a sexual assault nurse's exam or forensic nurse's exam following a sexual assault or an incident of dating or domestic violence. They're based at MedStar Washington Hospital, but can be dispatched to other DC hospitals if one were to show up at another emergency room at another hospital. So the Title IX investigation process, very quickly, is there's an initial intake and assessment period. So if you were to make a report to our office, we would determine whether you would want to participate in a formal investigation if it were to lead to that. If you were to say no, you don't want to participate in a formal investigation, you just want the, say, harassment to stop. In most cases, we can accommodate that and not pursue a formal investigation. In other cases, the university may determine that we need to pursue a formal investigation because maybe there's a danger to the larger community, and it's not limited to you and the people who you've mentioned in your complaint. But in that case, you would not have to be the complainant. We would take your statement as a witness statement. It would become a university complaint. The university would be the complainant. And we would pursue the investigation that way. We could then issue some of the interim measures and accommodations that I talked about earlier while we look into it or pursue the investigation. If you ever hear from our office asking for you to come in and speak with us, it does not necessarily mean that you're in investigation. Unless and until you receive a notice of an investigation from our office, you are not under investigation. Us reaching out to you could be because someone has mentioned you as a potential witness who may know something about the people or the parties or the place involved or the setting involved in a complaint. Each party, the complainant and the respondent, would have an opportunity to review a preliminary report written by the investigator and could request that we review additional evidence. They could request that we correct a statement where they may believe that they've been misquoted, or they may request that we interview additional witnesses. Once we resolve all of those things, there's a final report which says whether the person has been found responsible or not responsible for the Title IX policy violation. Either party, the complainant or the respondent, can appeal that finding. The appeal would consist of the provost reviewing the investigator's report. The provost will determine whether he wants to keep the investigator's finding, meaning that he agrees with it, or if he disagrees with the finding, he can change it. So for example, changing a finding from responsible to not responsible, or vice versa. And then each party would receive a final notice of findings letter. Just a quick note about FERPA in Title IX. You've probably heard of FERPA, the Family Educational Rights and Privacy Act, which gives you as a student the right to exercise a certain amount of control over the information that the university shares about you with others. So the way it applies to Title IX is that when you are involved in the Title IX process as a complainant, respondent, or witness, you have the right to have an advisor or support person of your choice accompany you. And so you would need to sign a FERPA waiver to allow us to discuss your case or to have a conversation with you or interview you or share information in front of this person. The other piece is that there may be information in the investigative report that is redacted because it contains yours or someone else's confidential or student information that's protected by FERPA. And finally, the possible sanctions for when one is found responsible, if one were to be found responsible for a Title IX policy violation, cover a range of things. So it's not just automatically that someone's going to be suspended or expelled. There's a range that could depend on what the violation was and other factors. So the possible sanctions can include community service, restitution, meaning someone having something restored to them that was lost in the process or as a result of the violation, required training or counseling, academic, disciplinary, or social probation, barring orders, so people can be barred from campus, no contact orders, up to suspension or expulsion for students, and administrative leave or termination for employees. You can find additional information on our website. We have lots of handouts that describe Title IX, your protections, your rights, resources, responsibilities, additional resources that you can access on campus. We have a frequently asked questions page to answer additional questions you may have, a page where you can download helpful documents. And our website is easy to find. If you go to the Howard University website, the main homepage of Howard University, you scroll all the way to the bottom and you will see the word Title IX. You click that and it will take you right to our website. And if you have any questions at all, any comments, any feedback, any concerns, and you'd like to reach out to us, you can contact us. Our contact information is available on our website. You can email us at title9@howard.edu. Again, when we are on campus, we have walk-in hours Tuesdays and Wednesdays, 10:30 a.m. to 2 p.m. But while we are working remotely, all of the information that I've shared with you still applies, and you can reach out to us via email or phone. So thank you for listening. Welcome to Howard University, and I wish you a great first semester and first year at Howard. Thank you.